God save the United States of America, the state of Florida, and the honorable court. Please be seated.
Thank you.
Standing room only
I
today.
know it. Another busy day at the 50CA. We actually do have 3 cases today, but this is the only one in person. The next 2 are live, and the next 2 are by Zoom. It's the only one in person. Good morning. I'm Judge Lambert, is our marshal, our new marshal. Aaron told us. I'm presiding over the panel this morning. Welcome to another session. Today is, for the record, Tuesday, December 6, 2022. We have 1 case, like I said, in person. You all are here. To my right, let me introduce the people on the panel. To my right, your left, is Judge Rand Wallace. And on the far left is Judge Jim Edwards. Couple things. We are obviously being recorded, so if you have any type of electronic devices or what have you, please either turn them off or in the mute, so that you don't bother Doug out there in the audience. Each side will have 20 minutes. I'll reserve 5 minutes for the appellant on rebuttal. Unless you want a different amount of time, then I'll reset the clock. You'll see the lights. The yellow light will be flashing when you get into rebuttal time. If you want to keep going, that's fine. I'll give you a reminder, though, as you're into it. The red light will flash, will show that you're past your time, and time to wrap up. If we've not directed to you, wrap up. All right, first case today is 22-699, Tara Lynn Parks versus Elisa B. Cunningham. So, counsel, whenever you're ready. Choose run. That's you? All right.
Your Honor, I'm the appellant. May I proceed forward to the lectern?
Yes, sir.
May it please the court. I've got to admit, I've got a few butterflies this morning. I don't do this very often. I don't consider myself an appellate lawyer, but since I've been working on this case for the last 9 years, I felt it appropriate that I be the one that present my client's case, Ms. Tara Lynn Parks, who I had the pleasure of representing.
Who are you? What is your name?
Eric Faddis.
Okay, thank you, Mr. Faddis.
Tara Parks, who I've represented since 2014 when her criminal case was dismissed for lack of identification proof. And so before I begin my presentation, would it be appropriate for me to ask permission from the panel just to allow me about 3 to 4 minutes to get out some points that I would like to make before questioning? Would that be a proper request?
You just keep talking, and when we're ready to ask questions, we'll ask.
Okay. First of all, we're here today regarding the effects of an affidavit. The substance is actually 2 pages. It's an affidavit, a search warrant, but the actual warrant is based upon a 2-page substantive affidavit of probable cause issued or executed by the defendant, Ms. Cunningham. And I just want to say that it's probably one of the shortest affidavits of probable cause that I've seen. It accompanied another 2-page affidavit that ultimately resulted in the prosecution and conviction of a second subject, the male subject, burglary subject. But if you looked at the affidavit, in essence, there's only 1 paragraph in the affidavit that addresses substantive issues that the officer was aware of, and it not only omits a number of very significant and exculpatory facts that she discovered, purports to have discovered in her work in developing probable cause between the late afternoon of October the 9th to the early morning, I think it was 8:09 a.m., that she confirmed that she had made this positive identification.
Mr.
And,
Faddis, is there any wording in the affidavit to you that supports your position that this prosecution was malicious?
well, to the extent that malice is inferred with the lack of probable cause, I would say yes, because under the law, the lack of probable cause infers legal malice. And so, if
So
I
you're
can-
saying the absence of wording in the affidavit makes this a malicious prosecution?
Well, not only the absence of wording, but the misrepresentation that she made that an officer, or excuse me, a Deputy John Causey of the Sumter County Sheriff's Department made, that he identified our client was patently a mischaracterization. And there is a record testimony. I took the deposition of Deputy Causey, and when he was confronted with what was contained in this affidavit, and we've got the citation in the record, Deputy Causey said that is a miscommunication, quote unquote miscommunication. Now, he's not sophisticated as a police officer. His words were miscommunication.
You were saying, sir, that you began your representation after the criminal prosecution had concluded? Is that correct?
Yes, Your Honor.
Okay. Was there a challenge to the affidavit made during the course of the criminal prosecution?
No, Your Honor. And let me suggest, and this is my respectful suggestion on why that didn't occur. When the public defender undertook, and that was Amanda Bogus, who's got an affidavit in the record that's been submitted on the lack of probable cause and the Brady violations. When the state attorney's office filed their discovery document, as they do in every criminal case, the state attorney, when it came to the itemized Brady evidence section of the standard document that's issued by the state attorney's office, they indicated, they check mark where it says none, they check mark none. So they made the representation to the public defender who is defending Tara Lynn Parks that there was no Brady evidence. Now that has some significance because defense lawyers rely on those representations by the state. And I don't think, and the public defender at the time, who is just former emeritus mayor of the city of Tavares, who also practices defense law as a public defender, she did not dive into the affidavit because there was a representation that there was no Brady materials or evidence. Had she known, and she says this in her affidavit, had she known that the defendant Cunningham had actually purported to have searched the police records, and had she known that the officer had discovered that Tara Lynn Parks' name was absent from those records, she would have attacked the probable cause. She would have raised Brady violations. She actually renders in a conclusion in her affidavit that this was a Brady violation for not telling us that Tara Lynn Parks' name had been discovered not to be in the police records. What significance does that have? It has a tremendous significance because here, and I'll tell you this, there were 3 firm identifications made before 6 p.m. and this is on October the 9th. And I'm characterizing it like this because as I thought about it last night getting prepared for this oral argument, I wanted to make sure that the court understood what was going on before 6 p.m. on October the 9th. And I say that because the 4th identification by Mr. Causey didn't come into the desk of Ms. Cunningham until 6:09 p.m. She had left her shift, and I've got record citations. She had left her shift at 6 p.m. She was on a 6 a.m. to 6 p.m. shift.
Did you provide those record citations to the trial court in response to the filing and the hearing, prior to the filing and the hearing of the motion for summary judgment in this case?
I believe I did, Your Honor.
The specific record citations?
Well, I can tell you this, that...
Because the trial judge thinks you didn't.
Excuse me?
reading the order here, the final order, the trial judge thinks you didn't.
Okay.
Thinks you didn't. I mean, he's talking about that on page 1659 of the record. Plaintiff did not file a written response in opposition to the amended motion for summary judgment in accordance with the requirements under the rule, which the rule was amended, and in fact, the judge actually did an order that's in the supplemental records to say, okay, look, we've had a rule change here, so we're going to have to start over and file your amended motions and file your response, and he's indicated you hadn't, which seems to be supported by the record, and that has consequences under the rule in 1.510, what is it, E, looks like 2 and 3. It allows the trial judge then to consider the fact filed by the defendants in the motion for summary judgment to be undisputed and to also grant summary judgment if the facts support it, which their affidavits would support that they didn't commit the torts that you've alleged against them. So that seems to be your initial big hurdle as to why that's not problematic. Do you follow what I'm saying?
Yes, I do. And if I may respond, Your Honor, to your comments, and I appreciate the comments. And this is not your typical summary judgment rendition. We had 2 hearings under the old rule. There were record submittals, and I can go through. Let me count the record submittals that
we get all that. That there, I mean, there is things that predate the amended motion by some time, but the judge, your trial judge, entered an order specifically saying, okay, we have a new rule. Here's the rule. You must do these things. That's what the Supreme Court's rule says.
Well, that's not. And out of all due respect, that's not exactly what happened in the case. After the new amendments to the new summary judgment rule went into effect in May, but before they did, we had the last hearing, and the judge, and that was back in, I believe it was April, and after the April hearing, the judge asked both parties to submit very detailed orders identifying for the record and proposing an order. I prepared a 27-page order, which was filed on May the 3rd in the record. Now, the judge, after the rule change, entered an order on my cross motion. That was the first order that he enters. He enters that on June 6th. He enters this order on my cross motion. See, this is not the typical case because I filed a cross motion under the new rule. When he entered his order on June the 6th, after the rule change, he directed his comments to me, not to the defense. He said, you must amend your motion for summary judgment, which is a cross motion. You must amend the summary judgment, and pursuant to the rule, I did a very detailed, I think 16-page motion where I recite all of the facts in conformance with the new summary judgment rules.
Was that cross motion set for hearing?
The cross motion is not set for hearing.
Okay. So
So
why are we talking about the cross motion then?
Well, because it is, you could say, it is tantamount to a response to her motion because the cross motion is on the same, it's on the same competing issues. Her motion basically was no probable cause, and immunity under the statute, no malice. Those are my issues on the cross motion, and I specifically tailored the cross motion to conform with the new rule pursuant to the judge's order.
So you were aware of the new rule before the hearing on defendant's summary judgment motion?
Well, obviously I was. The judge told us or entered that order on June 6th, and he said, pursuant to the new rule, plaintiff, you're going to have to conform your pleading and your motion for summary judgment to the new rule, which I did. Now, if you read federal common law, federal precedent, now this is a new rule that is enacted in in May of 2021, and I would respectfully suggest that if you construe the new rule, you have to construe federal precedent in conformity with the new rule and how to interpret it. If you go through, if you just did a cursory search, if you had your law clerks just run cross motion and pull all the cases that have to do with cross motions, you'll come out with a plethora of cases that dealt with an attorney's filing of a cross motion. And incidentally, in the federal rules, under federal law, there is precedent. There's precedent that says that if there's no local rule that deems assertions on a summary judgment motion like the defendant Cunningham, if there's no local rule that applies and says you must file, you can't dismiss. Well, the law says you can't dismiss. You guys can do whatever you want, and I'll respect that. But the federal law says without a local rule in the district where this summary judgment motion has arisen, if there's a cross motion for summary judgment and there's no local rule that establishes that if you don't file a response, the cross motion is considered by the judge because it is a location of the facts that, and I've got repeated citations that I made, and I did not put those in my briefs, but if you could just...
Sir, if you didn't put it in your brief, then it's not in the record on appeal. It's not proper to argue that here without notice to the other party.
Well, let me ask you, as to false arrest, does it have to be one of the elements is actual malice?
No, Your Honor. False arrest has the 6 elements.
That's malicious prosecution. That's 6 elements.
Oh, I'm sorry. I'm mistook. False arrest. The burden is on the defense to show there was probable cause, and we meet all of the elements of false arrest. And I'm not sure I answered Your Honor's question. Could I get some clarification specifically on that?
Does there have to be actual malice for you to be able to prevail in front of a jury on a claim for false arrest?
No, Your Honor. There does not have to be actual malice, and I think that's where the lack of probable cause comes into play under both rules. And that's why it's so important for you to review the 2-page affidavit that was executed, where there's nothing on the firm identifications. And that's where I wanted to go back and make these 3 points before I started asking questions, so I'll just make them now. If you looked in a time chronology on October the 9th,
you are into your rebuttal time. You can keep going if you want, but just so you're aware. But there's a clock in front of you, right?
Okay.
Okay, go ahead.
So I'm already past 15 minutes?
You can use all 20 minutes now if you want.
Have I used 15 minutes?
Yeah.
Okay.
That's why the clock is
Let me speed up, and I'll go until it...
I'm just letting you know that if you run out of time here, you don't get to rebut when they're done.
Okay.
And that's why you have a clock that you can look at to tell you how much time you got left.
There was a firm, I would say, this is how I would characterize it. There was a firm identification by Sergeant Scott Mack on October the 9th, a first firm identification in his exchange of emails. There was a second firm identification by Scott Mack, again, directing Officer Cunningham to look at the police records where the subject female's name was entered. There was a third firm identification by Miss Cunningham herself, who said, I've been out with the female, I just can't remember her name. Now, all of these firm identifications on October the 9th were recorded into the record by the 2 officers, and I'll cite you to a record citation in the deposition of Defendant Cunningham. She states at the record 803, line 15, quote, all of our activity is documented and kept. So when Sergeant Mack is telling her, go look at the police records, and she says, I've been out in the field with this suspect, I just can't remember her name. They were documented. These contacts were documented in the police records. And when she later purports, Officer Cunningham later purports she searched the records and there was no Tara Lynn Parks, she's actually establishing that Sergeant Mack's identification was of a separate and distinct female subject. And she herself, by saying she didn't find Tara Lynn Parks' name, she's confirming that first identification that she's made. Now, I'll say this. On October the 10th, she first reviews the email from Deputy Causey, and I've talked earlier about him saying he didn't positively identify her. He only thought that might be, and he hadn't seen her in a while. But she makes a second firm identification herself on a positive identification of Tara Lynn Parks. I've said repeatedly in my submittals, I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Just on Mr. Bradley's testimony, the experts, I have that many times I entered the substance of his opinion testimony between October the 26th and August the 30th of 2021 into the record. And the fact that his affidavit was not even considered by the judge is very troubling to me, and as well as Ms. Boggess' affidavit. Now, I'll reserve my 1 minute and 8 seconds, I guess, for rebuttal, and I appreciate your time, and I wish I had more time to submit my arguments. Thank you.
Okay. All right, counsel.
Good morning. May it please the court?
Yes,
Stephanie Briones on behalf of Detective Cunningham in the City of Leesburg. Your Honors, we're not here today to determine the guilt or the innocence of Ms. Parks, and I think that's where the standards really need to be held to. There are several threshold issues that support our argument that the trial judge was correct when he entered summary judgment, and the first has been addressed by this court, but I would just like to explain some of the semantics. Essentially, when we filed our original motion for summary judgment, the plaintiffs themselves actually filed a motion for partial summary judgment. There was no cross motion, cross notice, that kind of thing. So I think it's important to note that in the interim that these were separate motions that were on behalf of the plaintiff, never actually noticed for hearing and never heard. The reason that we had so many hearings on the summary judgment motions were because this case has been transferred through 4 judges throughout the course of the trial. And unfortunately, right after one of the hearings, the judge had to recuse himself because he realized that he was involved in the criminal prosecution of the co-defendant. So that's where we ended up with Judge Welke. And Judge Welke not only told us after the hearing, well, the rule's been amended and you need to make your motions, respective motions, comply with that new rule. We actually filed a motion for clarification because Mr. Faddis is correct in stating that the court appeared to have a typo in the title. After the hearing on only our motion, the judge accidentally said plaintiff's motion for summary judgment in the title. So it was a little bit confusing. We actually filed a motion for clarification, and the judge confirmed, yes, you have to file an amended motion for summary judgment and a response to the other party's motion for summary judgment in compliance with the new rule. No response was ever filed by the plaintiffs to our motion. We did file an amended response to their motion for partial summary judgment, even though it was never heard. So I think when you review the transcript of the actual amended motion for summary judgment hearing, the trial judge is correct and counsel acknowledged that they did not file a response, but they were instead asking the court to comb through the record to find all the other things they had filed throughout the course of this 7 years of litigation.
Ms. Briones,
Yes, sir.
what measures or what steps did Detective Cunningham take following the information that was gathered from Deputy Causey to verify the identity of Ms. Parks, or
Yes.
exclude the identity of Mrs. Parks?
Yes, sir. And I believe we do cite to this the aspects of her deposition. I just do want to point out that her deposition was taken nearly 6 years after this case was initiated, and nearly 7 years after the arrest. And
So there was no deposition taken of the detective in the criminal prosecution?
not that I'm aware of, Your Honor. In fact, in the criminal prosecution, the notice of information was filed, and it was not dismissed for several months.
Was the police report, did that contain any details as far as the follow-up that Detective Cunningham did with regard to the identification of the appellant in this case?
In some of the police report, Your Honor, and then also in the deposition testimony, essentially what we have here, this is not a type of case where officers were on the scene of the crime. This was a surveillance video that caught a burglary into a business. And so officers responded when the owner of the business found that the business had been broken into, there were tools. They pulled the surveillance video. Detective Cunningham had several photos, still photos from the video that depicted the woman. There was a woman and a man. The woman was a white female. The man was an African-American male. And the photo and video depicted both of those individuals. When she received what she calls a clue from Sergeant Mack, who said, "I believe this to be the male suspect's girlfriend," Detective Cunningham testified that she went through all the prior records with that male and when he had a female companion accompanying him, and that she did not see photos or video of an individual that matched the description that was easily depicted from the surveillance video.
Is there any description in the files of those cases that identified Ms. Parks?
No, sir. Ms. Parks did not have a criminal record, and we don't dispute that. But in addition to those steps...
Be a girlfriend without having a criminal record, correct?
Absolutely. Detective Cunningham also stated that this male suspect changed his girlfriends rather frequently. So a potential lead in that I think that's his girlfriend could be different from 1 week to the next. So if that individual, the male, was never pulled over with a female companion with him matching the identity of Ms. Parks, then there would be no record of Ms. Parks being on a traffic stop or something of that nature.
So other than combing the files of the previous encounters with law enforcement, what other steps were taken to verify the identity of Mrs. Parks by Detective Cunningham?
Yes, sir. So Detective Cunningham sent what's called an email blast to all law enforcement agencies in the area, and that's when Deputy Causey, who actually was a former City of Leesburg police officer now working at Sumter County, he responded and stated that he had firsthand knowledge of this Miss Parks because she was a friend of a friend that he went to high school with. And he has seen her in person in social events and that sort of thing. So he said, "This is who I think of, Tara Lynn Parks," and he actually provided Detective Cunningham with pictures from her Facebook page and her driver's license information, and then Detective Cunningham pulled that information along with her driver's license information. She reviewed the video and the snippet photos from the surveillance video and compared them. She also then took it to 3 other detectives within the department and basically presented them, here's the surveillance video, here's the photos, here's some photos of this person. And she didn't, she left it at that. She testified that it was department policy to do that. And 3 separate other detectives also confirmed that they believed that the individual that was shown in the surveillance footage was also the individual that was Miss Parks, as noted by her driver's license.
Was the context of those identifications, this is that same person, or was it this may be that person?
Detective Cunningham in her deposition said that she presented it to the detectives and they positively identified independently of her own suggestion. So she didn't suggest, I think this is who it is.
So as best you can tell me, what is the specific wording that was used to mean which you say conclusively is positively identify?
In her deposition.
This is the person, or this may be the person?
To my belief, Your Honor, from what was described by Detective Cunningham, both in her affidavit and in her deposition testimony, positively identified means a confirmed probable cause to believe this is the individual that has committed the crime. Not positively identified, when the word positively is left out, that has a significance in that when you read Detective Cunningham's affidavit, she says that Deputy Causey responded and said that it was Tara Lynn Parks. She doesn't say that Deputy Causey positively identified Tara Lynn Parks. She says that I positively identified Tara Lynn Parks using all of this other information. So when the other detectives in her own agency confirmed that positive identification, she took the next step and took it to the state attorney's office. The state attorney's office, it's procedure commonly in Lake County, as I'm sure it is in several counties. She took it to the state attorney's office. A state attorney looked at the affidavit before submitting it to a judge for issuance of the warrant, and the state attorney signed off on it, indicating there was sufficient probable cause, and then an information was actually entered by the state attorney's office, again confirming the probable cause, because certainly they thought there was enough of an identification to proceed forward to press criminal charges.
And this is all in her deposition, and because there's been no response to the motion for summary judgment, the trial judge has the discretion to consider those all undisputed and in your favor?
Yes, sir. And in addition to that, actually the measles case and the Siegler case, which is a 5th DCA case, measles is not a 5th DCA case, but both were decided after the new rule.
You mean Siegler?
Yes, sir.
2 of us were on that panel, look at that.
Yes, sir. The measles case goes into a bit more detail and it almost presents the exact scenario that we have here. The non-movement for the summary judgment motion was actually trying to convince the court in that case that since they had filed other information in the factual record 9 months before the rule was amended, that the trial judge should just consider that to be their response instead of ruling that they didn't actually respond in compliance with the new rule. And the court said, no, if you don't file a response, it's very clear that you must file a response is the language of the rule, and you must file that response within 20 days before the hearing. And that response was never filed, and it doesn't matter that you filed affidavits and you filed other motions for summary judgment on your own that were never noticed and heard a year before that. The judge is not expected to comb through the record to find your evidence for you.
So then the context of all this is that when the trial judge was listening to the summary judgment, your amended summary judgment motion, because there was no response, these favorable facts in your client's deposition can be considered to be undisputed in the context of the 2 causes of action brought against your client by the plaintiff. And then we have to wrap that around the statute, the underlying statute 768.28 sub 9, construing those facts as to whether there was bad faith or malicious purpose or wanton and willful disregard of the plaintiff's rights, that it should go to a jury and let them decide. And the trial judge said that combination of things there isn't, and that's why he granted the summary judgment. Is that what happened?
No, sir. I actually...
What happened for your favor?
Well, it is what happened in the sense that the judge did make note. The judge did make...
Tell me what happened instead.
Your Honor, I mean, it did, but I just want to be clear that, the trial judge didn't necessarily state that he considered everything undisputed, and I think that our case is favorable even if that weren't the standard. In other words, even if they had responded and cited all these prior materials, our case stands alone and is appropriate for summary judgment. And I'll tell you the reason why. There's another threshold issue that we get to before we even talk about probable cause and whether Detective Cunningham believes she did or not. Actual malice is not an element of false arrest, but it is an element to overcome an officer's statutory immunity under Florida Statute 768.289. And the case law is very clear that actual malice has to be shown, and actual malice is more than negligence. And in this case, the claim was originally brought against both the city and Detective Cunningham. The entire complaint and every version of it doesn't really allege enough to show malice anyway, even though they're conclusory allegations. But a long time ago, when we were hearing the second amended complaint, we filed a motion to dismiss, again raising statutory immunity and sovereign immunity, and Judge Hill dismissed this case with prejudice against the city because he basically gave the plaintiff an option. Either you can proceed against Detective Cunningham and try to overcome statutory immunity, or you can proceed and allege things like negligence against the city. And they proceeded to assert this claim against Detective Cunningham. I think it's really important to note that actual malice is a really, really tough standard. You have
Doesn't
to...
the statute say the officer can be liable under 768.2 if they acted in a manner exhibiting wanton and willful disregard? And that's just after it's in the disjunctive, it says, or with malicious purpose or in a manner exhibiting wanton and willful disregard. So if you don't act in a malicious purpose, but you meet the standard for wanton and willful disregard, can a governmental employee, in this case the officer, be liable under 768.289?
Yes, sir, but wanton and willful disregard has not been proven in this case either.
I know that, but you seem to say it has to be actual malice, and there's no actual malice, then there's no claim under 768.28 against the officer individually, and I don't understand if it's worded in the disjunctive.
Yes, sir. I think the focus on actual malice here is because the arguments throughout this case is they're saying she acted with actual malice and we're saying she didn't.
Are they saying they acted with actual malice? Because I think her testimony was, why your client would have a grudge against her. It's just that the actions in the efforts to arrest her and to prosecute her were malice as a matter of law, kind of legal malice, for lack of a better. I guess that probably is the same as malice as a matter of law, legal malice.
Yes, Your Honor. Legal malice has been construed in the malicious prosecution cases, and several Florida courts have sort of disagreed on, is it legal malice or is it actual malice for the malicious prosecution claim?
Did we say anything?
Yes, sir. You said that actual malice is required.
I did, or the fifth?
The fifth. I'm sorry, sir. And that's in Earp versus Carroll. It's a 1983 50 CA case.
That's actually from Ocala.
And it said doing harm for harm's sake is the standard for malicious prosecution, so it's more of an actual malice. There is absolutely no evidence that Detective Cunningham acted with any sort of malice or willful and wanton disregard, reckless disregard. There is no claim against a police officer in the state of Florida for a negligent investigation. If anything, could they argue she could have done more? Perhaps, but unfortunately that's not the standard. And Detective Cunningham took extra cautious steps by having a state attorney review. It wasn't as though she made an arrest on the spot in this case. She did look through records. She did confirm the identity with other officers. She took many reasonable steps. And an important thing to note that arguable probable cause is all that's required to defeat a false arrest claim when immunity issues are involved. And did she have arguable probable cause? I think based on the fact that she had a warrant that was issued by a judge that was based on her affidavit, that was confirmed by 3 detectives and reviewed by a state attorney before it ever went to the judge, that's conclusive evidence of probable cause.
But I mean, if she's the one that supplied all the bad information, I think, isn't the context of those things is for example, the officers who actually arrested Ms. Parks, they can't be, they just were honoring a warrant and serving
Yes,
a
sir.
warrant. I mean, I don't think you're not saying that if an officer gins up a affidavit with all kinds of false information and not tricks, but a judge is convinced to give the affidavit or sign the warrant, that you're free as a matter of law from a false arrest or malicious prosecution.
Absolutely not, Your Honor.
Okay, all
Yeah.
right, just wanna make
And
sure.
I think in that scenario, which cannot be proven here, this whole issue boils down to one little block of words that was not contained in the affidavit. So we've talked about this affidavit, as you can imagine, over and over in this case. Deputy Causey responded to the email and said, "This is who I think of, Tara Lynn Parks. She's a friend from high school," or something like that. Okay?
Can you
And-
look at her picture then, too, the Facebook picture?
Oh, yeah, the Facebook picture,
so he-
and Deputy Causey still to this day believes he properly identified her, and that he still believes it was her depicted in the video. He's actually been in the same room with this person at social gatherings and things like that.
Ms. Parks,
Yes, sir.
okay.
And, Your Honor, the only thing that was different in Detective Cunningham's affidavit is the language that she used. She said, "Deputy Causey responded to my email and said it was Tara Lynn Parks." Then later, she says, you know, I used her driver's license photo, her Facebook information, the video and photos of the surveillance to confirm and positively identify Ms. Parks. So because Deputy Causey said, "This is who I thought of," and she didn't put, "This is who I thought of," she said that he responded to the email and said, "This is Tara Lynn Parks." She doesn't take the extra step to use those buzzwords that he positively identified. She's not misrepresenting anything. And there's nothing in the affidavit that is a lie or a misrepresentation. And I would argue, Your Honor, if there was such a lie or a misrepresentation, it would have to be extremely egregious, but that would also constitute bad faith. And, you know, she wouldn't be protected by immunity. But there's absolutely no evidence of bad faith or wanton and willful conduct here, as admitted by Ms. Parks herself.
You got 20 seconds if you want to wrap up.
Yes, sir. And it's important to note that we don't Monday morning quarterback the decisions of police officers. If they have arguable probable cause, just by virtue of the fact that the case was dismissed later, has no bearing on whether there was actual probable cause or arguable probable cause at the time of arrest. And so both the lack of malice and the sufficiency of the probable cause would defeat any malicious prosecution claim as well. Thank you for your attention. I appreciate it.
Thank you. Okay, Mr. Faddis, rebuttal.
Thank you, Your Honor. I just have a couple of points that I wanted to make. In the February 3rd, 2021 hearing, the first hearing that we had on the first motion for summary judgment, Ms. Briona says, quote, and this is at page 14 of the hearing transcript, she says, quote, he would have a different female with him every time. That statement made it into the court's order granting summary judgment. That is a misrepresentation, and I'll get to that in just a second. Second, she says in the hearing transcript, quote, her supervisor, and this is the February 3rd, which is filed of record at page 14. Second, he says, her supervisor, Sergeant Mack, said, you know, I don't know who this female is, quote unquote. That was a representation to a trial judge by the defense lawyer. And let me read the record evidence that's a matter of record in this case.
That was the sergeant saying he didn't know who it was?
Yeah, that's Ms. Briona saying the sergeant said he didn't know who this female was. Let me quote the sergeant in his deposition.
This is your last thing because you're over your time.
Okay. It's, quote, it seems to me, and you correct me if I'm wrong, that there's no uncertainty that you are certain it's Lance. Would that be fair? That would be fair. So I take it that you had multiple contacts with the female who you, and he says, I would say probably that's my thoughts were at the time. Yes, sir. When you say frequently with him, that connotes to me that on multiple occasions you connect this female, this white female to him. Yes, sir, I would. He also says during his testimony that he was certain, but by the fact that you did not include that statement, you were certain it was Lance and his girlfriend. Answer, that's what I would take from this email. Yes, sir. One last thing, Your Honor. One last thing. She says that malice is required on that 76828 qualified immunity statute. I wrote in the brief, there's a cite to LeMay versus Condrick, 923 Southern 2nd, 1188 at 1191. It's a 5th DCA case. It overturned immunity denied under willful or wanton conduct shown by police because that standard, the LeMay case recognizes the use of a lesser standard defining willful and wanton conduct, quote, willful and wanton conduct is generally something more than ordinary negligence, but less than deliberate conduct. And so it's not an actual malice standard under the immunity statute.
Okay, thank you. All right, we will stand adjourned. We got to go to a Zoom OA now, so have a good day.